In this video, I shall discuss about the Minerva Mills Case 1980, a landmark judgment of the Supreme Court. But before that, let me go back to the independence of India. When India became an independent nation, it was plagued with this legacy of zamindari, or landlords carrying these huge parcels of land. And in a country which is developing, requiring land for a lot of development projects, also to distribute among the landless, this didn't make much sense. And redistributing this private land to public purpose was something also in line with the doctrine of eminent domain. However, there were certain articles within the fundamental rights section of the Indian Constitution which literally prevented the government from taking any such step. Article 14, for example, the right to equality. Article 19, which among many freedoms also contained the right to property. And Article 31 itself, which contained this right to property. That is, no one can be deprived of his or her private property. So this made things difficult. So in 1951, the Indian Parliament passed this first Constitutional Amendment Act, in which two articles were inserted in the Indian Constitution. Article 31A, which enlisted certain laws, among them being the estates acquisition laws as well, which could not be held null and void in any court of law, on the ground that it contravenes either Article 14 or Article 19 of the Constitution. Furthermore, it also inserted an Article 31B, which created this basket called the Ninth Schedule. Remember that the Indian Constitution originally had only 8 schedules. Now it has 12 schedules. But the Ninth Schedule was inserted, and it was a basket which could contain any law which cannot be held null and void in any court of law on the ground that it contravenes any fundamental right. I repeat, any fundamental right, not just Article 14 and 19. And this gave huge overriding powers to the government. Anything that it didn't want the courts to strike down as ultra vires, it just put in this basket called the Ninth Schedule. And therefore, over the next 1 decade, almost all the zamindars' lands were acquired by the government. And this was hailed as a huge achievement. Now fast forward to the 1970s. Because of the socialist pursuit of the government of the day, it required the nationalization of a lot of industries and factories. You remember those series of nationalization acts, the Bank Nationalization Act of 1970, which nationalized the 14 largest banks of India. Then the Coal Mines Nationalization Act 1973, General Insurance Business Nationalization Act 1972. But what interests us is the Sikh Textiles Undertakings Nationalization Act of 1974. I'll discuss about this. But in order to justify all these nationalization acts, which in some ways violated the Articles 14 and 19 of the Indian Constitution, the government had to create a new Article 31C, which it did via the 25th Constitutional Amendment Act of 1971. Now, what is this Article 31C? It stated that any law made by the government in order to promote the directive principles 39B and 39C could not be held null and void in any court of law on the grounds that it violates the fundamental rights via Articles 14 and 19. Plain and simple. And if you see Articles 39 bracket B and 39 bracket C, this is what it states, that the policy of the state will be such that the resources and ownership of those resources and materials shall be distributed in such a way that it fulfills the common goal. In other words, a socialistic pattern of resource distribution. And then Article 39 bracket C, that the economic system shall be executed in such a way that the concentration of wealth and means of production shall not result in common detriment. In other words, a very socialistic pattern of distribution of the means of production and wealth. We can remember the words of Karl Marx, literally. So, because all the nationalization and any such law of the government can ultimately be justified in terms of these articles, it became easy for the government to find its way out using this new Article 31C. And then in 1973, the famous landmark Keshavanand Bharati case judgment was passed, which created this doctrine of basic structure. And Articles 31A, B, C, 9th Schedule, nothing was held unconstitutional or against the basic structure of the Constitution by Keshavanand Bharati. which is why in the Minerva Mills case of 1980, nothing was repealed. Only the amendment to Article 31C, which was done in the year 1976, that was repealed. So, what is this Minerva Mills? Minerva Mills was one of those textile mills which the government sought to nationalize because it wasn't working properly. And the aggrieved moved the court. So, the main concept in this case, the main controversy in these petitions centered around the question whether the directive principles of state policy in the Part 4 of the Constitution can have primacy over the fundamental rights in Part 3. That's the heart of the matter. And there were two particular sections in the 42nd Constitutional Amendment Act of 1976. Now, because things are getting really hot and technical, I don't want you to become confused. So let me say one thing, that it was during the 1970s that the government did a lot of things to pass whatever law it wanted to pass without the Supreme Court striking it down. So it did this 25th Constitutional Amendment Act in 1971, and after the basic structure doctrine was passed in the Keshavanand Bharati case, even after that, it came forward with the 42nd Constitutional Amendment Act, which said, and I quote, there was a section 55 of this act which said that no amendment of this constitution shall be called in question in any court on any ground. In other words, just put it outside judicial review. It also said that there shall be no limitation whatever on the constituent power of the parliament to amend the constitution. Overriding powers. Overriding. And that's a very dangerous thing, because the limited amending power of the parliament was the basic structure of the constitution, which the Minerva Mills bench held. And the parliament cannot, under the exercise of that limited power, enlarge that very power into an absolute power. And therefore, this section was held unconstitutional in the Minerva Mills case. First point completed. Now let's move on to the second point, and that is regarding Article 31C. Article 31C, the petitioners wanted that to be eradicated completely. The Minerva Mills bench said that, first of all, this article was not repealed by the Keshavanand Bharati bench. So who are we to remove them? Secondly, in 1976, an amendment was made to this article which can be removed. Let's see. What was the amendment made? In Section 4 of the 42nd Constitutional Amendment Act 1976, it said that notwithstanding anything contained in Article 13, it said that no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Articles 14, Article 19, or Article 31. And no law containing a declaration that it is for giving effect to such a policy shall be called in question in any court on the ground that it does not give effect to such policy. So let me make things very clear. In the original Article 31C, it was there that only these directive principles 39B and 39C can have primacy over the fundamental rights 14 and 19. But in the amended Article 31C in 1976, each and every directive principle of state policy had primacy over the fundamental rights 14 and 19. And that was held very dangerous, because you could literally water down the fundamental rights. And this is a very dangerous thing, because it violates the rights, first of all, conferred by Articles 14 and 19. It subordinates the fundamental rights conferred by Articles 14 and 19 to the entire Part 4 of the Constitution. And so the scope of laws which fall within the purview of Article 31C were vastly expanded by this amendment. And it robbed the fundamental rights of their supremacy, made them subordinate to the DPSPs, as if there was a permanent emergency in operation. Because we know that when an emergency is in operation, then via Article 359, the president can prevent the enforcement of the fundamental rights. So, if the fundamental rights are prevented to be enforced all the time, it's as if a permanent emergency is in place. So, this amended Article 31C was destroying one of the basic features of the Constitution, namely the harmony between Parts 3 and Part 4. And it was creating a foundation for an authoritarian state. This is what the Honorable Judge Nana Palkiwala had said during this case, and the Attorney General in that case vehemently opposed this claim of the Honorable Judge. And a lot of discussion and debate was held, and finally this amendment of Article 31C was removed. So as of today, Article 31C is still valid only insofar as the DPSPs 39B and 39C are concerned. 31A and 31B and 9th schedule, all of them are valid. But this overriding power which was provided in the 42nd Constitution Amendment was removed. So apart from that, we always see that in the Minerva Mills case of 1980, this was the tendency of the Supreme Court bench to give power to judicial review. That you can't have any law made under Article 368 outside judicial review. And you can't have any law made even under Article 31C outside judicial review. They also said that even when the president proclaims a national emergency, it cannot be outside the judicial review. So this power of judicial review was overarchingly emphasized in the Minerva Mills case of 1980. I won't bog you down much. So lots of technical cases are there. Lots of important landmark cases of Supreme Court are there. Keep your mind free to read and understand all of that. And I shall be discussing many of them in further videos. So meet you all next time. But do subscribe, like, share and comment this. And do subscribe to News and Statics. Meet you next time, folks. Bye-bye.